Greetings to all of you who are joining in the present or the future. I am very excited to welcome you once again to another session of Africa in the Moot's Open Access Education and Training Series in the context of the 32nd Willem Cephas International Commercial Arbitration Moot. Always a mouthful, but here we are nonetheless. My name is Erin, and I am a director of Africa in the Moot, and I'm joined today by Dr. Fabricio Fortese, one of Africa in the Moot's valued education committee members. And now for those of you who are new to this series, Africa in the Moot is a non-profit volunteer-based organization which supports sub-Saharan African teams to participate in the FIS Moot. If you are tuning in, you will know that the FIS Moot is the largest commercial moot court in the world, second only to the Jessup, and it typically draws hundreds of university teams to participate globally. But unfortunately, historically, and that history is now changing, sub-Saharan Africa's participation has been less than 1% of that. But we at Africa in the Moot and all of our volunteers and partners know that there is immense talent on the continent, and we support our teams with coaching, training, funding, and access to resources with education series such as these, so that they can best participate in the really exceptional educational experience that is offered through this 8-month FIS Moot journey. And we're very, very proud to confirm that for this current FIS Moot season, after just 4 years of operation, we are currently supporting 19 teams from 14 different countries across Africa. And that means that sub-Saharan African participation has increased by over 400%. So we hope that you will meet some of these wonderful student beneficiaries in Vienna or Hong Kong very, very soon. And now, as is a tradition in these education series, which I've broken from, we usually start by saying good evening, good afternoon, or good morning, depending on where you're tuning in from. But that really truer than for our session today, as I look to our esteemed panel of who is joining us from different regions around the globe. And now you may have experienced already that the joy and the pain, depending on what mood you're in or what situation you're in, of international arbitration practice is that it does take you around the world, whether that is through your client or your tribunal's jurisdictional background or your applicable law or laws in the case of a conflict. But today's discussion on use of confidential and settlement communications in international arbitration is going to give you some insights on how these matters are dealt with in different jurisdictions. Of course, as is the case with all of these education series, we are looking at issues that are relevant not only for the FIS Moot, but as the FIS Moot imitates what's going on in arbitration practice, issues that are very, very relevant and topical for the practice today. So we are, on that note, very, very excited and grateful to be joined by 3 leaders in international arbitration, each of whom has a very, very extensive and impressive resume, which I cannot run through on this call because I think we'll all be here until next Tuesday, and I'm much more interested to hear what they have to say, as I'm sure you are as well. So I do encourage you to follow them online and reach out with your favorite procedural or substantive questions. And you will find their information on Africa in the Moot's website, but also our social media pages. And now, turning to introduce these fantastic speakers, I will start ladies first with Elodie Dulac, who is a partner at King & Spalding Singapore office in the International Arbitration Group. And she is admitted to practice in England and Wales and Paris, France. She is also a registered foreign lawyer at the Singapore International Commercial Court. So as you can glean, this is experience very extensively from the Asian markets, but also from the common law and a bit of a civil law perspective. And then turning to West Africa, we have the great pleasure of welcoming Isaiah Bozimo, who is a senior advocate of Nigeria and a partner at Broderick, Bozimo and Company, and a former Attorney General of the Delta State. He is also currently the Vice President of the ICC International Court of Arbitration. And finally, as always with these things, it's last but not least, and also representing another civil law view, we have Dr. Bernd Ehle, who is a partner at LALIVE in Geneva, Switzerland, and specializes in international arbitration and is also Swiss qualified. He is also a member of the Arbitration Court of the Swiss Arbitration Center and the Executive Committee of the Foundation for International Arbitration Advocacy and a fellow of the Chartered Institutes of Arbitrators and is very much involved with an African practice. So I told you it would be long. I think I've saved some time, but let's rather dive into the discussions now and get into the topic of what we're talking about today. There is, I think, as you may have experienced as a young arbitration practitioner, and certainly in the Moot problem, a lot of talk about without prejudice and what that means. It can be a confusing term, it can mean simple things, and it can mean so much more. But starting with Isaiah, perhaps you can explain to us what is a without prejudice document, and what does it actually mean for a document to be labeled as without prejudice? And further on that note, does labeling a document without prejudice give it any kind of protection? And can you make it, can a party unilaterally confer that protection? So Isaiah, over to you. Oh, I think you are on mute.
My deepest apologies. I didn't
No
start off under. I was just expressing my pleasure to say what a pleasure it is to be on this call, and in support of such a worthy cause as well, in supporting the development of students and talents on the African continent. And it's a pleasure to be sharing the stage with Dr. Ehle and also Elodie as well. And I look forward to your views on this topic. Without prejudice, yes, very interesting topic. It essentially relates to a communication or a document that is made by one party to another party as part of a genuine attempt to settle an existing dispute. Now, if the privilege applies, then that document becomes inadmissible in evidence. So it's quite a powerful tool, and a number of questions arise from me. So firstly, why does the privilege apply? Well, there are some public policy reasons behind it, because public policy favors encouraging the efficient settlement of disputes. So the protection allows the parties to negotiate freely in an atmosphere without fear that their words will come back and be later used against them in the event that the settlement discussions fail. So that's all well and good, but what communications, what documents, what then will the privilege cover? The documents can take any form. It could be by way of letters, emails, text messages, even oral discussions between the parties. So what matters the most is not how the communication was made, but why the communication was made. So if the purpose of the communication was to resolve the dispute through negotiation, then it may be protected and it will be excluded or may be excluded from the body of evidence. Now, the protection is not automatic, right? Because you can imagine it could be abused. So for instance, there is a document that doesn't favor a particular party, and in attempting to exclude it from the evidence, they will mark it without prejudice. Well, that in and of itself is not sufficient. As I said, the dominant purpose of that communication must be for the genuine settlement of a dispute. So generally speaking, the protection will only apply if three conditions are met. So primarily, there must be an existing dispute. So it will not apply to routine commercial discussions between the parties. Secondly, the communication must be aimed at settling the dispute. So if it merely asserts a legal position, it may not be protected. And finally, that communication must be genuine. It must be a genuine attempt to resolve the dispute between the parties. So the parties simply can't use it to label discussions to shield admissions that are unrelated to settlement. Now, another question that comes up is, to whom does the privilege belong? Now, that's an important question because it determines who can waive that privilege. Well, it belongs to all the parties. So if there are two parties, it belongs to both of them. If there are more than two parties, it belongs to all of them, meaning that one party can't unilaterally waive it, right? So if one side tries to introduce a document that is made without prejudice in the proceedings, then the other party has two choices. It could either object to the admissibility of that document or that communication, thereby preserve its privilege, or it can consent. And in that case, it would make the entire body of communications admissible in evidence. And another thing we should be mindful of is there can't be a partial waiver of the communication. So, for instance, a party can't disclose a part if one part it finds helpful and conceal in other parts that might be unhelpful to it. So if one chain of the communication becomes disclosed, then the entire chain also becomes disclosed. So I've said a lot, I'll try and summarize. So that the dominant purpose of the communication must be a genuine attempt to settle the dispute. It is not automatically applicable. The tribunal will have to balance the purpose for which that document came into existence. So that's my summary of it. I'm interested, of course, to hear what the other panelists might think on this as well.
Thank you very much for its very comprehensive overview and very, very informative indeed. I'm curious turning to Bernd. Don't look nervous, but what is your view and your experience from your civil law background on these issues?
Yes, thank you. First of all, it's a pleasure and a privilege to be here and to share some of my thoughts and my experience. So from the civil law perspective, and I'm like Switzerland and Germany, the jurisdictions that I'm most familiar with, there's no direct equivalent to the common law without prejudice rule. Instead, there are some other protections, similar protections that arise from certain legal principles, such as the principle of good faith, which is a cornerstone principle that provides a foundational protection and also applies to settlement negotiations between parties. And this principle requires parties to negotiate honestly and can create an implied confidentiality obligation during settlement talks. Then in civil law jurisdictions, you also often incorporate protections in procedural codes that are obviously not directly applicable in arbitration, but there's in the legal culture, there's an understanding that if settlement talks are going on, that those are confidential. But in order to make sure that the confidentiality does exist, there's usually an explicit confidentiality agreement. And in my experience, this is exactly what happens when parties have settlement talks. This is the first thing they discuss is, are these talks without prejudice or not? Are they confidential or not? And so generally speaking, I think in civil law jurisdictions, the parties need to be a bit more proactive about protecting the settlement communications through explicit agreements. And if they have not done so, they sort of run the risk that they do not get the protection that they would like to have. And similar to what Isaiah said about common law, the simple labeling of a document as being without prejudice does not automatically confer protection in civil law jurisdictions. So there's no automatic effect, and you have to look at certain facts that are similar to what Isaiah just listed, which are whether the document was indeed exchanged in the course of genuine settlement discussions, whether the parties had agreed on confidentiality explicitly or implicitly, and whether disclosure would violate good faith obligations or unjustifiably harm legitimate expectations of confidentiality. So it's very much a case-by-case decision that a tribunal would take. And to the other question about whether or not the party can unilaterally confer privilege on a communication by marking it without prejudice, it's the same answer that Isaiah has given for common law. The short answer is no. A party cannot unilaterally impose such protection. It's the whole content and context that determines whether a communication is privileged or confidential. So that ideally there must be a mutual agreement, and you have to prove the mutual agreement that there is confidentiality. And again, you would look at good faith. And well, a tribunal that is faced with this may recognize the confidentiality of settlement discussions by looking at the agreed procedural rules, soft laws, and so on. But I think we'll get into that in more detail a bit later. I also looked at the question, which laws govern the characterization of a document as privileged? And that is something that is pretty straightforward in the national court litigation context, where you have, all questions of privilege are basically governed by the lex fori, so the law that of the jurisdiction where the court proceedings take place. In international arbitration, there is no simple and straightforward answer to the question of which law or laws govern the characterization of a document as privileged, and there's no single and predefined definitive framework for that. There's not even consensus among civil law jurisdictions upon whether this is a matter of procedural or of substantive law. So there's a whole list of possible laws that interplay and where the tribunal has sort of to choose from, a toolbox. You have the law of the arbitral seat, the lex arbitri. You have the law governing the arbitration agreement, if that has been specified. You have the law governing the underlying contract and the merits of the dispute. Then you have the law of the jurisdiction, where the document was created or communicated, the national laws of the parties who are involved, the law of the place where the parties' counsel are qualified, and then in addition to that, you have institutional rules and possibly procedural orders and issued by the arbitral tribunal. And when trying to find out among all these different possibilities which one to choose, tribunals have a very broad discretion, and they usually apply approaches that we know from private international law or conflicts of laws. So, for example, the most favored nation approach, meaning that they apply the rule that is more or most protective, the most protective privilege standard among the potentially applicable laws. And this approach usually respects best the legitimate expectations of confidentiality and prevents also an unfair advantage to one of the parties. Another standard is the closest connection test, where the tribunal would assess which jurisdiction has the strongest connection to the document and its privileged status. And obviously, so these two tests, and then they look also at maybe common principles that would apply between the parties, national laws, and soft law, such as the IB rules on the taking of evidence. But ultimately, this is really a question of discretion for the tribunal, and they obviously will make sure that they observe party equality, the efficiency, fairness of the proceedings, and the legitimate expectations of the parties. There's always a remaining uncertainty, but this is my experience in practice.
Thank you very much. Elodie, do you agree? Is the same perspective in Singapore or in Asia in general, in your opinion and experience?
Yes, I fully agree with what Bernd just described. The position, if it was, for instance, Singapore court is very established, it would be lex fori, quite typical. Arbitration CEDR in Singapore, as anywhere else, as discussed, it's broad discretion of the tribunal. I think if you take the counsel perspective, what that means is you have several laws available. If they all support your position, the lex fori, the laws of the parties, like you plead all of them. If they don't, you try and pick and choose or say, well, just transnational approach or something vaguer. And I think the important, like comparing national court decisions on privilege and what a tribunal would do, especially if you don't have a fully English law tribunal, for instance, would be the weight of like the fairness and the equality of the parties and the parties' expectations, which is mentioned in the IBA rules, would definitely play a very prominent role in how the tribunal approaches. And I've had like a case where I think I must say I haven't had like a lot of cases where actually privilege like becomes a big issue, which is considered extensively. But when I've had, and including cases involving states, so very sensitive, actually tribunals, even if both parties plead various laws, ultimately the tribunal can find a way to just basically not choose one. And arrive at what seems to be a fair and predictable result, it will go that way.
I suppose the arbitrators might have been guided by the applicable arbitration rules as well, right? That helps them. They're different depending on the ICC. The UNCITRAL rules are different when it comes to identifying the applicable law when the parties do not agree. But let me quickly move on to a different question, which is obviously related, and that deals with internal discussions. When there are settlement negotiations or proposals, does privilege also apply to internal communications?
Yeah, so maybe I'll give the Singapore/English law perspective, because Singapore law largely follows English law and privilege, and Bernd can add the civil law perspective. So if it depends who's involved in these internal communications. So if you have an in-house counsel involved in the discussion, in Singapore, the Evidence Act has been specifically amended a few years back to include in-house counsel in the definition of what's legal professional advisor, which is like the relevant category for privilege purposes. So if the communications involve an in-house counsel, and in the exercise of its role as in-house counsel, that legal advice or these discussions involving between the commercial team and the in-house counsel will be privileged, and that's in the Evidence Act. Then there's a question: what happens if you don't have, if the internal discussion is between the commercial team? Then there isn't any case law on point in Singapore, so the usual test on privilege would apply, which is that the relevant documents came into existence when litigation was pending or anticipated in contemplation. 1, and 2, looking at the dominant purpose of the communication, the document. Was it for use in connection, in connection with litigation pending or anticipated? There hasn't been any case law in Singapore applying that test in the context of internal commercial settlement discussion, but there is a case in England, and usually, again, Singapore courts are following English courts on that, and I've quoted English case law. So there is a case in England by the Court of Appeal in WH Holdings, which was an issue of emails exchanged between board members discussing a potential commercial settlement. And the question was, were these emails between the board members on commercial settlement privilege? And the court took a restrictive approach, which is in line with a restrictive trend, I think, in the English case law on that. And the court found that these communications were not privileged because they were not created for the purpose of obtaining information or advice in connection with litigation. And these were between non-lawyer staff regarding potential commercial solutions to a dispute, which can come out as quite counterintuitive because these discussions were in relation to the settlement of the dispute, but they were deemed not to be privileged. This decision has been criticized, notably if there had been in this discussion or in the room an in-house counsel or even a discussion of legal advice, the relevance of to the legal outcome, then this would have triggered privilege. But that's the case law which was most, which is on the common law side, which is most on point and is taking a very restrictive approach to internal settlement communications between commercial staff. And maybe I turn to Bernd for the civil law perspective.
Yes. Thank you, Elodie. So the situation in civil law jurisdictions is again different because civil law jurisdictions do not always recognize litigation privilege as broadly as common law jurisdictions, because the focus in civil law jurisdictions is slightly different. It's on professional secrecy, which primarily protects communications between external lawyers and their clients. But this protection stems from the lawyer's professional obligation rather than the litigation context itself. So internal company discussions, including about settlement proposals and communications with third parties, even when they are prepared for litigation, generally lack the privilege protection. There are some minority views that say they should be included, but the majority views that they do lack this. So you have to be very careful, actually, because communications with in-house counsel often, because they lack this protection, and even with experts hired directly by a party, may not be privileged. So this narrower civil law approach is sometimes surprising to parties from common law jurisdictions who find out that certain documents they consider as privileged are potentially discoverable when civil law rules apply. And obviously for an arbitral tribunal with parties from civil law and common law jurisdictions, this is very challenging and tricky, because they may find themselves in a situation where you have asymmetric disclosure obligations, and then they have to find a way out. And we mentioned some of those before, the most favored nation principle, but eventually the tribunals are usually very keen to establish some level playing field between the parties and look at what the parties' expectations were, and then you have to understand that the arbitrators also run the risk that if they apply the privilege incorrectly, they risk the setting aside of the award or even the refusal of enforcement of the award. So it's quite tricky. If they ignore the privilege without a justification, they violate the arbitral due process, at least for one of the parties. And if they reject evidence based on a wrong understanding of the privilege, they violate the right of the other party to be heard and to present its case. So in my experience, what is sometimes done, but actually not enough in real cases, is that the parties at the beginning, the tribunal and the parties sit together and they try to find a way forward, a privilege agreement at the outset of the proceedings, which could be recorded in procedural order number 1 or a similar document, to make sure there is a level playing field, because especially when civil law jurisdictions are relevant, this is not an easy task to do.
Thank you very much. I'm sort of nodding my head and can see my own face in the screen, just nodding along very happily. And this has been really, really helpful and informative so far. I have a question now, just turning back to Isaiah. There's obviously a lot of terminology, but that's been thrown around, and I think certainly for lawyers and the Moot students to grapple with. But obviously there are significant nuances within the terminology. So what distinguishes so-called without prejudice protection from litigation privilege in settlement negotiations?
Okay, excellent question. And again, it can be very confusing because while they can both arise in the context of settlement discussions, they have very different purposes and they apply under very different conditions as well. And what the student should look out for is the context in which these documents or these communications were made. So if I go back to my initial intervention where I said without prejudice, protection will allow the parties to negotiate freely by ensuring that genuine attempts to settle can't be used as evidence. Now, those communications are between the parties themselves in or as part of a genuine attempt to settle the dispute. Now, litigation privilege applies under different circumstances. So I could probably sum it up into 4 stages. So firstly, there must be either existing litigation or arbitration, or the litigation or arbitration must be reasonably contemplated by the parties. Secondly, the communication must be confidential. It must be either between a lawyer and a client, or it must involve either the lawyer or the client and a third party. For instance, the client or the lawyer is consulting with a potential expert witness on a damages aspect of the litigation, right? And you're given advice based on that expert opinion. And fourthly, and most importantly, the dominant purpose of communication must be to obtain legal advice that is in connection with litigation. I'm using litigation in a broad sense here, so take it that I'm including arbitration in that conversation. And I'm sticking with litigation because the name of this privilege is litigation privilege, but it will apply to an arbitral dispute as well. So if I was to do a side-by-side comparison, you could ask yourself different questions. So primarily, what does it protect? So litigation privilege will protect legal advice in connection with pending or anticipated litigation, right? Without prejudice protection will protect settlement communications between the parties. Who makes the communication? In legal privilege protection, it is, litigation privilege, it is a communication between either the lawyer and the client, between the lawyer and a third party, or between the client and a third party, but it must be in connection with obtaining advice for pending or existing litigation. In without prejudice protection, one party is communicating with the other party in engaging in settlement talks. And another critical distinction, and Elodie touched on it earlier, is that the involvement of lawyers, right? It can have a very big effect. So if, for instance, in their internal discussions that are discussing commercial risks of settlement, it might not be protected under privileged communications. But if a lawyer is involved, and again, if the lawyer is given advice in connection with those proceedings, then it might be protected depending on which legal rules apply. And also for without prejudice communications, the involvement of a lawyer is not required. It's between the parties. Then you ask yourself, who owns the privilege? And this is an important question because it tells you who can waive the privilege, right? So for litigation privilege, it's owned by the client alone, the client to whom legal advice was given. So if that client voluntarily, for instance, discloses that information, then that privilege is waived. Whereas in without prejudice protection, it is owned by all the parties jointly. So one party cannot unilaterally waive it. One party simply can't attempt to introduce it in evidence and it will be waived. No, it has to be waived by all the parties. So it is open to the party who wants to reserve that privilege to object to the document in question. And does it apply to internal discussions? This is the gray area. And again, this is where you really need to look at the purpose for which the communication is made and who is involved. It could, for litigation privilege, it is only, again, if the dominant purpose is for obtaining legal advice in connection with arbitration or litigation. And for without prejudice, it will not apply to internal discussions. It will only apply to communications that are exchanged between the parties. So I hope you follow that, but you can see that there is a risk inherent in internal discussions about settlement strategy. And what you need to look here is whether is it in connection with legal advice or is it simply routine commercial discussions regarding business strategy. So if the internal discussions focus on seeking legal advice on a settlement strategy, then it may be protected by litigation privilege. If they assess purely commercial factors, so for instance, financial risks, reputational concerns, then the privilege will not apply. So how can you mitigate against this? Involve lawyers as early in the conversation as possible, right? Because then you can frame it as being legal advice in connection with proposed settlement. And again, pay very close attention to the dominant purpose in the context of litigation privilege. So even if litigation is ongoing, litigation privilege will only apply if the dominant purpose is to obtain legal advice. If the document, for instance, serves a dual purpose, so if it's part legal, part business, then the privilege may not apply unless the legal advice aspect is the primary reason for its creation. Again, lots of nuances. I hope I've clarified rather than clouded, but happy to answer any questions that may arise on the back of this.
So, sorry, I guess the Vismus students are going to be very happy to hear your answer.
Okay.
No, that's absolutely clear. I mean, thank you. You really are taking us through and giving a very detailed overview. And what I understand from the overview is that indeed there's a very fine line in establishing privilege or not. But I think lawyers around the world will also thank you for the advice that you've given about involving lawyers from the beginning. And turning now to Bernd, Isaiah has set out a lot of information about what you can do to establish that privilege. But what risks would arise from referencing privileged materials in settlement agreements?
Yeah, there's several risks that one has to consider. And the first one that comes to mind is the waiver of privilege. As Isaiah mentioned earlier, there can be a waiver to privilege, an express waiver, where the privileged materials, such as legal advice or internal legal assessments, are explicitly referenced in a settlement agreement. And this privilege may be waived, making those materials disclosable in future disputes. Or an implied waiver, which can exist even if the privilege is not expressly waived, but where the referencing of these privileged materials may be interpreted as a waiver. And so one can mitigate this, obviously, by including an express non-waiver clause in the settlement agreement. So that's one way of doing it to mitigate that risk. Another risk is the unenforceability of the settlement. Because if the settlement agreement refers to certain privileged material, and then later on a dispute arises about the agreement, the tribunals who are looking at that dispute may require the disclosure of the referenced privileged communications. And so the whole settlement agreement may itself become unenforceable without examining the referenced privileged materials. And this is also called the confidentiality paradox, because it can undermine the very party's intent of keeping those documents confidential. And another one is the confidentiality breach, obviously. So if the settlement agreements are often confidential, but if the privileged materials are incorporated into them, the scope of confidentiality may be challenged, and the counterparty might later argue that the inclusion of those materials means they can be used in other proceedings or disclosed to third parties. And a final one risk that I thought of was regulatory or third-party disclosure obligations. For instance, in the finances industry or in public contracts, there might be a regulatory obligation requiring disclosure of settlement agreements. And if those privileged materials that are embedded in the settlement agreements might inadvertently force disclosure to regulations or third parties.
There's a very interesting point when you refer to the settlement agreement where there are references to privileged materials. But Elodie, do you have a different opinion when it comes to incorporating the privileged information and negotiations and make them part of the settlement agreement?
Yeah, so maybe I mean, it's quite a specific fact pattern, but there is actually a case in England by the Court of Appeal which had that factual scenario in BGC in 2019, where there was a settlement agreement and it referred to a privileged communication in the body of the settlement agreement, and it also annexed a series of communication between the parties. And then there was an argument as to whether the document referred to, the communication referred to in the body of the text and the annex, and the ones in the annex, whether they were covered by legal privilege. And that's what the court did, and what, as I mentioned in common law, case law, really the dominant purpose is key. And that's what the court looks at. The party which was seeking the disclosure was arguing that, the party which was arguing the privilege, the legal was arguing that these communications were included as part of evidence gathering for the dominant purpose of the conduct of litigation. The court didn't agree. It found that these communications were incorporated because they were needed for the other party to enforce the reps and warranties in the settlement agreement if needed. So here, actually, like Bernd mentioned, the risk about the enforcement of settlement agreement. Here, the court actually found the fact that these communications were needed to implement, or should it be not complied with, to implement the reps and warranties in the settlement agreement was the dominant purpose, and for that reason there was no privilege. So yeah, it's very fact specific, but the bottom line is in the English case law and English inspired like a common law case law, you would look at the dominant purpose, and that would be basically what would determine whether the privilege applies. And here in that case, the parties that said actually provided they did waive privilege, but the court didn't. Basically, that wasn't determinative. The court looked at the dominant purpose of the inclusion.
Right. Yeah, at the end of the day, it might become problematic when it comes to admitting them into the arbitration, and then it will create what Bernd talked about, the enforceability perhaps of the arbitral award. So Bernd, could you expand a little bit more about on what document or evidence could be protected by confidentiality in arbitration proceedings, and what would be the basis for the protection?
So as a general introduction, obviously in international arbitration, confidentiality stands as a cornerstone principle. Although, of course, as we discussed, its breadth and the application vary significantly based on the governing legal framework, the selected arbitration rules, and any agreements between the parties. And as we all know, the private nature of arbitration represents one of the primary advantages that motivates parties in the first place to select arbitration over traditional litigation in the courts. So regarding the categories of documents and evidence that are or could be protected by confidentiality, there's obviously the pleadings, the submissions, and the awards. So most arbitral rules and national laws provide that the awards, the parties' written pleadings, and other procedural documents are not public. And the institutional rules such as LCAA, ICC, and so on, they impose more or less strict implied confidentiality obligations. And some jurisdictions, such as England, recognize arbitration as inherently confidential, while others, like the United States, do not. Then we have the evidence submitted in the arbitration that is also often considered confidential. And the basis for this is usually that there's a procedural order, and oftentimes the parties seek additional confidentiality provisions in the terms of reference or in an ICC arbitration, or they ask the tribunal to order additional confidentiality, for example, in procedural order number 1. And there may be, obviously settlement communications and without prejudice documents that we have talked about here, and trade secrets and commercially sensitive information as well. And I thought I would also briefly just mention what parties can do in circumstances where the evidence of this nature is used in arbitration. And obviously there's the possibility to immediately object and raise a formal objection as soon as the privileged material is introduced. They can request protective orders from the tribunal. They can challenge the document admissibility. And something that is often done is also to seek adverse inferences on costs, or impose additional costs on the other side that has produced those documents. And there are obviously other ways of dealing with that, such as asking the tribunal to review certain documents in camera, so separate from opposing counsel.
Great, thank you very much. I'm very taken by your input. It's sort of went into another world thinking of how I can apply this in my own matters. So thank you for that. And now turning back to Isaiah, what law governs the admissibility in arbitration documents such as settlement offers that are made during negotiations outside of a mediation context?
This is one of those "it depends" answers.
Yes.
It very much depends. But the start point is the tribunal's broad discretion to determine the admissibility, relevance, and weight of the evidence presented by the parties. So the material question then becomes, well, by which rules will the tribunal assess that standard? So which rules will the tribunal apply to determine whether a document is admissible or not. And here you could look to several factors, one of which is the lex arbitrage, the law of the place for the arbitration. So, for instance, in common law jurisdictions, as has been hinted, the courts and tribunals generally uphold a very wide protection of the without prejudice rules. So without prejudice communications will be inadmissible generally, unless one of the parties can show that an exception applies. So for instance, in proven misrepresentation or the existence of fraud or of a concluded statement. Whereas in civil law jurisdictions, as Bernd has highlighted, that protection is much more narrow, and it often stems from confidentiality obligations rather than a distinct without prejudice rule. So disclosure in those circumstances will be more restricted, right, than it would be on the applying, for instance, common law principles. And the lex arbitrage might not even apply, because it would depend on whether in the jurisdiction in question evidence or the admissibility, more specifically, is a question of procedural or substantive law. So it would apply generally if it's a question of procedural law under the lex arbitrage. If it's a question of substantive law, then you may have to look to the law applicable to the main contract. So very many different puzzle pieces, and the tribunal is always balancing each of these considerations in trying to determine which law will apply. And then you might have actual privilege and confidentiality protections in agreements between the parties. So for instance, the contract might have confidentiality clauses. There might be agreements between counsels, undertakings between counsels during settlement discussions. There might be procedural orders issued by the tribunal itself, which will be binding on the parties. Then, aside from all of this, there is a question of public policy and fairness. So even where privilege or confidentiality does not apply, tribunals may exclude settlement documents if admitting them would undermine the fairness of the proceedings. So I recall Bernd's earlier intervention where he said the tribunal has this obligation to maintain the equality of arms between the parties. And because they come from different legal traditions, there are reasonable expectations as to what is protected and what is excluded could be materially different, depending on whether they come from a civil law or a common law jurisdiction. So it really does depend. It depends on multiple factors. So you're looking at the arbitration rules, you're looking at the tribunal's broad discretion, you may be looking at the procedural law of the lex arbitrage, you may be looking at whether documents are protected by privilege or confidentiality, any private agreements between the parties, and public policy considerations. I hope that answers it.
And then some, definitely. And now another question for Elodie. We have touched on and mentioned the IBA rules on the taking of evidence in international arbitration already, but can you take us through how these address legal privilege specifically?
Specifically, I'm not sure.
It depends, I guess.
So the IBA rules do have a couple of provisions which address privilege in Article 9.2. Mentioned that basically refers to the terminal Mediator document, admissible for various reasons, and one of these reasons is legal impediment of privilege under the legal or ethical rules determined by the arbitral tribunal to be applicable. See Article 9.4 below. So it sends you to Article 9.4. Article 9.4 mentions that in considering the issues of legal impediment or privilege under Article 9.2b, which I just read, and insofar as permitted by any mandatory legal or ethical rules that are determined by it to be applicable, the arbitral tribunal may take into account various factors which which are listed in A to E. But importantly, none of these factors it's a kind of a factors the tribunal may take into account. It doesn't have to. It may take into account other factors, or only some of them in a balancing act. And I think what comes out of this Article 9294 is the tribunal broad discretion. It doesn't have to even apply a national law or a specific national law. The only boundary to that discretion is mandatory legal or ethical rules, but again, which the tribunal determines to be applicable. So this is very loose. It's basically what the IBA rules do is that it gives like it recognizes that legal privilege can be a ground for a document to be inadmissible. This doesn't advance really matters much further, and the IBA has actually set up a task force on privileged international arbitration. For now, what the task force has done is produce a number of reports of basically comparative law, identifying how different the approaches can be between countries, and in particular, you see broad differences between civil law, common law approaches. Down the line, this task force hopefully will issue some guidelines to help tribunals, because right now tribunals aren't given much guidance, they are given discretion. But what they do with that discretion is very much up to them. So I think at this point, the IBA guidelines are kind of referred to give some hook to pleading legal privilege, to resist document production, but the substance, the meat of it has to come from elsewhere, because it's not in the IBA rules.
Thank you very much. Steen, I would like to stay a little bit more in the IBA rules and guidelines when it comes to taking note of evidence. And the question is, what constitutes a waiver of legal privilege?
So is a question for me, or? Yes.
Yes, please.
So what constitutes a waiver is equally kind of left open or within the tribunal discretion. There is nothing specific on what would constitute a waiver in the IBA rules. So again, you would fall back to your type of conflict of laws approach, a transnational approach, tribunal discretion based on what rules it's going to be applying to the waiver. The task force in that respect has identified again like the varying approaches. I think what can be generally the case is that tribunals want to allow a pick and choose approach, which means you waive the part which is helpful to your case, but you argue the rest of the email chain is privileged. So I think the tribunal generally won't allow that approach. But then there are a lot of basically also like issues which are the task force is working on, but as of now would be tribunal discretion about what happens if you have an inadvertent disclosure. The question of the collateral waiver, basically if you produce an email which gives only a particular your view, like a portion of the broad picture, do you then have to waive, are you deemed to waive privilege on all the emails relating to that issue? So these questions for now they are not addressed in the IBA rules. The task force is working on them. So where you stand now is you would have to basically appeal to a tribunal discretion, whether conflict of laws or other means. And to give an example, I had an issue of waiver of privilege in one of my cases where both parties pleaded both the law, it was a governmental issue of waiver privilege. Both parties pleaded the law of that country and the law of the seat of the arbitration on privilege. What happened is that there was in a court submission in a parallel proceedings about the same dispute, that party had referred, had produced a letter, and that letter referred to some internal, basically legal opinion from the AG chamber. What we did in the arbitration is we argued, and successfully, that privilege had been waived because the document referring to that other document had been produced by that party before the court. And the tribunal actually didn't really embark into a conflict of laws approach. It just basically made a factual finding. You produced it in the other party produced it in a court proceedings. It's deemed to have waived privilege. And then the tribunal found as well that any communication referred to in that document were also the waiver also applied to this. So everything has to be produced. So that's kind of like a factual example of what like can constitute in practice a waiver, and the tribunal actually being quite practical and not, in that case, very eminent arbitrators weren't very dogmatic about the conflict of laws approach.
Thank you very, very much, Elodie, for your overview as well. I see that there are quite a lot of comments on the comment section. Where else would they be? So now we can move to a Q&A portion and take some of the questions. I guess the speaker should be prepared for the fire round. Yeah, let's see how it goes. First question, perhaps we can project it on the screen if that's possible through the arbitration channel. It's addressed to Isaiah, and that is, how does litigation privilege apply to documents created during settlement negotiations? So we're going back to the nuances with you.
Okay. It's another it depends answer. It depends on who made the communication, to whom the communication was made, and for what purpose. So let's look at different scenarios. So let's start with, for instance, communications between opposing parties. Generally, litigation privilege will not apply here because if the communications flow in from one party to another, a genuine attempt to settle the dispute, it will fall under without prejudice privilege rather than litigation privilege. However, if in the course of the discussions, one party shares a privileged document, such for instance, legal advice or internal legal assessments with the opposing party, then they may have waived that privilege. Right? And once the privilege is waived, not only does that document become admissible, that is to say, the document that previously enjoyed litigation privilege, but the tribunal could require the disclosure of related materials because it wants to prevent selective or misleading use of evidence. So it would want to see, for instance, the context in which the document was waived. So your parties have to be really careful in terms of what they're sharing with the other side in settlement discussions. Now, in internal discussions on settlement strategy, of course, a different approach will apply. If the legal teams or external lawyers are assessing settlement options, they're drafting strategy documents, or they're providing legal advice for the potential settlement risks, then those documents may be they may be covered by litigation privilege. The key factor is, again, please do not forget this, determine what the dominant purpose of the communication is. If it's to seek or provide legal advice in connection with litigation, or in this case arbitration, then the privilege will likely apply. However, it will not apply if the purpose for the document is purely commercial. So, for instance, the UK decision in WH Holdings that Elodie earlier referred to, the court found that the internal board emails there about settlement proposals were not privileged because they contained commercial rather than a legal analysis. And then you may get circumstances where documents may initially qualify for litigation privilege and then enjoy without prejudice privilege at different stages of the proceedings. So take, for instance, a settlement offer that's drafted by a lawyer. All right, that's generally considered to be covered by attorney-client privilege. Now, if one of the parties then uses that document as part of the settlement discussions, then it will enjoy without prejudice protection, notwithstanding the fact that legal advice was involved. So it very much depends on, again, who is making the communication, for what purpose, when was it made, but again, pay close attention to the purpose of the communication. It will only attract litigation privilege where the dominant purpose is in connection with legal advice for pending or anticipated litigation.
Thank you. Thank you very much for the answer. We have another question, and this is a bit of a challenge for me because it has a phrase in French, and I don't speak any French. But the question is this: does the use of the French phrase "sous réserve d'usage" in civil law jurisdictions confront the protective equivalence to "without prejudice"? Eloisa, I guess that question is directed to you.
Yes. I guess, and I haven't come into that phrase in arbitration, so I'm going to venture that I think it would look like the same meaning as without prejudice, but then what its effect is going to be in an international arbitration, you would have to take the same approach basically as who is involved for what purpose. So I think, again, the labeling is not determinative. So if I'm thinking like this is used in an arbitration in Singapore, you basically have to translate the concept and what was the purpose of the determinant purpose, the dominant purpose of the document, and the labeling doesn't get you there.
Yes, actually in Switzerland, in Francophone Switzerland, this is also used, sous réserve d'usage, and it's used in litigation, so court litigation, if you have communications between lawyers that are supposed to be without prejudice and should not be produced in litigious proceedings, then this is the phrase that is being used. I've not seen this being used in arbitration, so I think in any event would then, as Elodie just mentioned, have to be interpreted. What exactly did the parties intend? What is the document that has been labeled sous les réserves d'usage? So it's I don't think there's an automatic privilege that is attributed to this sentence, unless you're in the local court proceedings. Then I think there's a standard that applies to the sentence.
We have another question from the audience, which is related to the involvement of lawyers when they're seeking advice. But well, we're talking about lawyers giving advice and to have the protection of the privileged information. Does it also include in-house lawyers?
Maybe I'll just say, like I mentioned before, like Singapore perspective, that yes, it does, because in-house lawyers were added to a definition of legal advisor in the Evidence Act. So that was specifically addressed and provided for in the Evidence Act. So assuming they're acting in their capacity and providing legal advice, or that the communication or discussions are for the purpose of giving legal advice.
In civil law jurisdictions, it does not, as I mentioned earlier, it does not automatically apply also to in-house counsel. At least in Switzerland, I know that in the European Union, this has been a huge debate, and I'm not quite sure what the situation is today. It might be different in different states of the European Union, but it's a big debate. And to be sure, I think parties need to be very careful what kind of documents they exchange internally with their in-house counsel.
Thank you. We have another question. Actually, it's a different element to what we've been discussing without prejudice versus litigation privilege to documents. But it is, what will be the difference between a without prejudice contract and an NDA? And wouldn't it be safer to rather have an NDA instead of a without prejudice agreement or arrangement? So I'm looking to the group for volunteers. Otherwise, I'll call out someone.
I'm happy to try and answer on this one. So the purpose is different. An NDA is usually signed when a party is provided confidential information that it should not disclose to anybody else. Just keep it to itself. Whereas with the without prejudice contract is that you you don't want this document to be used in proceedings if the settlement fails. So I think that the purpose of an NDA and a without prejudice document is different. At least from a civil law perspective. I don't know what the others think.
No, it would be exactly the same on our common law perspective. So just as you said, without prejudice communications will arise where one party does not want to use their concessions, their offers made in the context of a genuine settlement to be used against them in subsequent proceedings. Whereas an NDA, you are receiving information on a confidential basis and promising that based on that receipt, you will not disclose, so that they apply to certain different contexts.
Thank you. We have another question that is related to the law applicable to privilege. We've heard that the common answer is, well, it depends. Many laws could apply. But the question is related to party agreement. When the parties have agreed on the law applicable to the contract, the substantive dispute, shouldn't that law also apply to the question of privilege information?
Well, that might depend on whether the question of privilege is determined as a matter of the law of the contract or as a matter of the law of the place of the arbitration. And different jurisdictions have different approaches. If you were to take, for instance, my jurisdiction is Nigeria, then it would be determined as a matter of procedural. So that might bring in the law of the place of the arbitration as opposed to the law of the place of the contract. Certainly, in the international arbitration context, tribal law, for the IBA rules undertaken as evidence will certainly weigh up the relative advantages of making a disclosure versus the prejudice that a party will have. So they might be they will look at all the circumstances to ensure that they maintain equality of arms between the parties and to ensure that the parties do not suffer a radically different position than they would have expected at the time the material communication was made. But of course, I'm happy to hear from the other panelists on this point.
The question reminds me of a situation I was in a few years ago where we were counsel in a case that was seated in Paris. The applicable law was Kuwaiti law, and the counsel was Swiss from our side, but some of our team members were also French qualified. And on the other side, there were US lawyers. And, you know, applying Kuwaiti law to these questions of privilege and of, you know, the ethical standards to be applied by counsel on both sides, being Swiss, French, and US, was not easy. And I don't think that it would have done justice to the situation. We're not talking here about privileged documents, but it was more about other aspects of testifying as an attorney, etc. But I don't think it would always do justice. So the applicable law to the merits of the contract are one of the various laws that I mentioned earlier, the 6 or 7 or 8 different possibilities that a tribunal can look at and find a level playing field, but it's not necessarily the governing law on the merits.
Okay, I'm just scrolling through the chat to see, well, there's one more question we can take. I'm just conscious of the time as well. And that is, I think, a very optimistic question, very relevant for the first moot. But in what state can a without prejudice agreement be admissible when it comes to any arbitration disputes? So, and I think in this context, state means country or the context of an applicable law. Any takers?
Well, I'm going to mention the case I mentioned earlier in England, where a document which the party had provided referred to in a settlement agreement, which were the parties that provided were without prejudice. Then the court found otherwise, looking at the dominant purpose of their inclusion in the document. So going back again to the fact without prejudice label isn't the end of the analysis.
So just following on from that, it would certainly depend in which country the question comes up. So Elodie has given, for instance, the UK position on that question, and it will be judged in accordance with the standards applicable in that state. So if it's litigation privilege, then they're looking at whether the dominant purpose is in connection with legal advice for pending arbitration or litigation, as the case may be. If it's another jurisdiction, and I speak under the control of my colleagues from civil law jurisdictions, then the protection will not be as wide, and that particular communication might not align with what the standards are under the state making the interpretation.
All right. Thank you very, very much. Before we move to close the session, I'm going to, leave the floor open for 30 more seconds to find out if anyone has any final comments or questions that you want to pose to each other. Feel free. I'm seeing happy, smiling faces, so I take that as a polite no, thank you. We're done with talking now. I had said earlier that this panel was a very diverse collection of leading global practitioners in the international arbitration space, and that is absolutely true. I had also said that everybody reflecting that diversity was joining from a different country and speaking to their arbitration experience in different regions. And in fact, you may have noticed, if you didn't, then go back to the beginning of this video and scroll through to the end, that the light has changed in everybody's background, and that's the natural light, I might say. So everyone's joined from a different place where daytime is doing its own thing, but this indeed speaks to the really wonderful dedication to this kind of program and the exchange of ideas in this context. So on that note, a really heartfelt thank you and a second thank you to our speakers, Bernd, Isaiah, and Elodie, for sharing your experience and your extensive knowledge through a very, very proactive and insightful discussion. And thank you, of course, to my dear co-moderator, Fabricio, always a pleasure. And then to our partner, the Arbitration Channel, who is our partner in this open access education series of Africa in the Moot, which makes this open access series much more accessible and professional. And I guess, if you'll permit me, I'll close with one pun and one tradition. The pun is, it has truly been our privilege to host you. And the tradition is that I wish everybody a very good morning, a very good afternoon, or a very good night, wherever you may be. So thank you so much, and please do follow up with these speakers. You will find them on LinkedIn, whether they want you to or not, you will find them, and please learn from them. That is exactly what this program is for. So thank you.